Good evening. Now we are playing ICAI Moto song. I request all the participants to put their right hand on their heart.
Yaesha Sukteshu Jagrati Yaesha Sukteshu Jagrati Kamam 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 Shlo Every Mara Adeva Shuklam Adeva Mritam
Now I request Chairman of Ahmedabad branch, CA Fenil Shah, to give his opening remarks. Thank you.
Thank you, Bishan Bhai. Shri Pramod Kumar ji, Vice President ITAT Mumbai, the speaker for the evening, CA Harit Dhariwal, Vice Chairman of Ahmedabad branch, CA Bishan Shah, Secretary of Ahmedabad branch, and members attending this very fruitful webinar, and a very apt topic because normally whenever we want to establish litigation as a practice, we are always worried of the department of the ITAT, and Ahmedabad branch is so privileged that today very learned speaker from ITAT itself is going to address us, the chartered accountants, that yes, how we can this litigation and we can develop litigation also as one of the career opportunity for chartered accountants. So on behalf of Ahmedabad branch, thank you Pramod sir for accepting the invitation and sparing your valuable time to guide all the chartered accountants of Ahmedabad.
Thank you.
Now, before we move with the session, I have some few very important announcements. The very first is with respect to that on 1st of July, Ahmedabad branch launched the virtual GST help desk because various issues were there with respect to GST. So branch took an initiative to launch the help desk, and the chief guest was Shri Ajay Jainji, the Principal Chief Commissioner of CGST from Ahmedabad. And friends, all the members can make the use of this particular help desk. Any kind of grievance you have, you just go to our Ahmedabad branch website. There is a tab available, GST help desk. Just click on that. A form will open. The rules are there. You submit your query, and soon you will receive the answer with respect to that. So I request all the members, and you can also extend this benefit to your clients also, that they can access this particular help desk and they can get all their queries redressed by using this particular GST help desk. One another important is from 7th July, that is 7th, 8th, 9th and 10th July, branch is having a very crucial and important advanced GST course. And now this is going to be held on a virtual basis, but in very systematic manner with respect to grievance solving, with respect to submission of queries, that you will never feel that it is going to happen on a virtual basis, but yet it is happening on a virtual basis. So I also request all to take the benefit of that particular GST advanced course also happening at branch from 7th, 8th, 9th and 10th of July. And since last 4-5 months, we all here and you all will admit that apart from professional knowledge, apart from everything, one thing which is coming out is our personal immunity, and something which helps to maintain the immunity is the fitness. Two types of fitness, physical fitness and mental fitness. And friends, Ahmedabad branch has launched the fitness challenge. It's going to start from 6th of July for 21 days. And tomorrow is the last date to register. And friends, this is not just the fitness challenge given just for the sake of fitness, but once you join this on 5th of July evening, we are going to have an induction session where the experts from fitness will guide you that how to make the best of this challenge. Daily basis, the track will be kept. Every Sunday, there will be a follow-up session and a very fruitful fitness challenge is there. I request and urge all the members to take the utmost benefit of this first ever opportunity to join the fitness challenge. You can join, your family members can join, and even your relatives and friends can join in this journey of establishing fitness as a habit. With this brief words, I again thank Pramod sir, and now I request Harit to take the session ahead.
Thank you, Fenil. Respected faculty for the session, Honorable Vice President of ITAT, CA Pramod Kumarji, Chairman of the branch, CA Fenil Shah, Secretary Bishan Bhai, and all the dear members listening to this webinar. Very good evening to everyone. We all are gathered here for the much awaited session on the direct tax litigation as a career for chartered accountants. Though Pramod sir is known to all of us, I would give a short introduction of sir for many young chartered accountants who might be listening to him for the first time. Honorable Pramod sir is the Vice President of ITAT and he has been in government service since 2000. Before joining ITAT, sir had practiced as a chartered accountant for 15 years in Delhi. During his stint at ITAT Ahmedabad, which we all can recall and remember, apart from numerous path-breaking judgments, sir had also brought about revolution in administrative issues by introducing plethora of changes right from suo motu identifying and cases and issuing a consolidated order to dismiss cases which are within the new monetary limit, or introducing standardized font size and spacing, judicious use of papers to adopt environmental friendly approach at ITAT. Sir, we have been following and learning from your judgments, and the way your orders have been drafted are commendable. I would like to share the recent order wherein first time in the history of 79-year-old ITAT, a division bench of ITAT led by Tribunal's President, Honorable Justice P.P. Bhatt and Honorable Pramod Kumar sir, through web-based video conferencing platform, heard and disposed of an urgent stay petition even as the tribunal was closed because of COVID-19. And sir, that was a big relief to the SSC, and all thanks to your efforts, and that shows your commitment and zeal to serve the profession and the nation at large. Sir, whenever we have met you or got a chance to interact with you, we have learned so much, and this is an amazing opportunity for all of us, including the young chartered accountants, to learn the direct tax litigation aspects from you. On behalf of all of us, sir, we welcome you as an expert in direct taxes, a role model for all youngsters like us, and a truly humble human being. Thank you so much for joining today, sir. Thank you.
Thank you so much for your very kind words. Shall I start my presentation?
Yes, sir.
Yes, sir.
Thank you so much, Mr. Fenil Shah, Mr. Harit, Mr. Bishan. Fenil, thank you for very kind words, and thank you for your concern about the fitness. Who would know it better than me? I mean, I'm an obese person. Today I weigh 100 plus, in fact, much more than that, 125 plus. And when I was your age, probably I was just 56 kgs. So I can tell you a little carelessness on this front can make your life miserable. No matter how good a professional you are, no matter what position in life you are, but if you don't take care of your health, things can be really, really difficult. And I'm happy, Fenil, that a profession has leaders like you who are so much concerned about these fundamental issues. And I would, on behalf of Fenil, urge each one of you, at least take a lesson from me. I mean, I hail from a army of, from a family of army men, and I'm the only Lalaji in my family, and that's all because of my carelessness. So for God's sake, whatever else you learn from me, fitness is not the thing. And I would urge you, looking at my own experience, to please fully get involved in every fitness program that the institute initiates. And particularly when you are young, you are, let's say, something below 40, then you can mold the body, whichever way you want it.
Yes.
So even if there are some issues, please address them now. There's nothing more important. This seminar, anything else in the world can wait, but fitness cannot. And in the COVID days, we have learned it the hard way that if there's something which is really precious in our lives, that's our own fitness, and that can help us fight the battles. So I'm glad that you started on this note. Harit, thank you so much for your very kind words also. I deeply appreciate the fact that you took note of some of the initiatives that were taken during my 4-year-long stay in the Ahmedabad benches. As a matter of fact, Harit, and I can tell all my professional brothers and sisters, that when I work in the tribunal, I'm reminded of the famous son of Gujarat, Mahatma Gandhi, who said, everyone is a trustee and you are trustee for the larger public good. Today, when I work in the tribunal, I interact with new people, or I interact with the tax officers, or I interact with the taxpayers. By the virtue of being in this office, God has given me the opportunity to take lead, to do something meaningful in the interest of all concerned, and that's their interests in a manner which is fair and equitable to the society. So to that extent, I'm glad that whatever little work I do, you go a long way in encouraging and appreciating it. And as I said, whatever opportunity God has given me to be in this public office, I treat this as an opportunity to serve the society at large and to be their trustee. So to that extent, I'm your trustee. It's my job to defend the interests of every legitimate stakeholder in the society in whatever role I play. And I always do that. Whether it comes to how do we function in the COVID days, whether it comes to our proactive action regarding identification of appeal. And I'm so privileged that I have my leaders who have been very kind and generous in encouraging me for these things and ensuring that whatever little work I do, they facilitate it further. So I'm very happy to be here with you today and to have this opportunity of what I believe is an interaction with you all. As a matter of fact, an interaction with the young chartered accountants particularly, and for that purpose chartered accountant generally, is always a delight. And that interaction is not even a patch on the experience which I'm having today, sitting in front of a computer and assuming that I'm interacting with some 200 odd people. That's not a patch. I don't know I can't see a body language. I can't see those familiar faces. I can't even see which portion of my words you like and which probably you would say, hey, come off. Move on to the next. So there's a disadvantage in talking through the virtual mode. But then let's look at the brighter side. The brighter side is that even in these tough times of COVID, where our life has completely changed from what it used to be till, let us say, 1st March 2020, there's at least an opportunity to interact and share some thoughts. As I started to, when Harit called me a few weeks back and wanted me to be in the Institute seminar, and he wanted me to speak about my journey as a chartered accountant and how, my coming to the tribunal and what are the takeaways from this journey. I was really taken aback. I was taken aback by the fact that some people, someone has been thinking about it. Someone has been thinking about the life journeys of the other chartered accountants who have not chosen profession or who have come to the other avenues like this government job and other forums. And secondly, I was impressed by the fact that he took interest in tax litigation career. And I can tell you very honestly, when I decided to speak to you, so many memories started flooding. Memories of my own journey of last 37 odd years, more than 1.5 decade as a chartered accountant in practice, watching this tax litigation as a bystander and then being in the arena, then of last 20 years as being in the income tax appellate tribunal when I've been adjudicating on the tax appeals. And of course, for last couple of years, after becoming vice president, when I'm involved with the administration of this institution. It has been a very, very interesting journey, and I can tell you it has been a fascinating journey. What we have seen is there are good memories, there are bad memories, there are memories about the encouragement given to the youngsters, there are memories about the ruthlessness of the system, there are memories about how young and promising chartered accountants like these three gentlemen I had with me in the panel just a couple of minutes back, how these people have shaped their careers, how I've also seen how people get upset about the problems which they encounter when they see the real world of tax litigation. This is a tough word. It's a tough word, and I must say that although there are a large number of chartered accountants, but it's a word where you have to compete with the lawyers who have an edge in the sense that those practicing as lawyers also practice before the higher forums like Honorable High Courts and Honorable Supreme Court. As a matter of fact, you will find many of those who have been primarily a chartered accountant chose the law profession at a later stage to make their mark in the litigation profession. Whether you think of people like Harish Salve Sahab, who was a chartered accountant, and he used to assist his father. And it was in a chance encounter with Mr. Palkiwala that he decided to pursue law. And then today he's one of the top lawyers, not only in India, but probably all over the globe. He has been contesting cases in International Court of Justice. And all this is started as a chartered accountant, when he was briefing a lawyer. So you can imagine even those successful lawyers in your own city, you see people like Mr. Saurabh Soparkar, who is a chartered accountant turned lawyer. You see people like what's his name, Mr. Tushar Hemani, Mr. Devatia, and I'm sure there are many more. I don't even know the names, but who have made their mark in the law profession, who are primarily chartered accountants. So undoubtedly, as a chartered accountant, you have an edge in many ways. In many ways, the way you understand business, and that probably makes you more relative for having a profession in the litigation career. But then only very few people choose it, and that's because, as I said, it's a tough profession in the sense that initial years in the tax litigation profession are very tough, and you go through the gradual stages as to how you progress. Talking about just one more thing, I must tell you. As I said, this is a process which is most interactive. I don't even see you. You are able to see me, but I have no benefit of knowing what's crossing your mind. So what I suggest is that just to make it little more interactive and to make it little more lively, please keep sending your questions, your comments, your thoughts, so that I have the benefit of knowing what you want me to speak on. I have the benefit of knowing what's crossing your mind, which I can address. So at any stage of this presentation, please feel free to send your messages on the chat box. And if you want, I can give you my WhatsApp number. So I'll have the benefit of having these messages with me right away. And since it's a WhatsApp number, this is not on my regular telephone. It's a WhatsApp I'll be using just now. So I'll give it to you just in a minute. So you can use that phone. You can send messages to Mr. Dhariwal, Mr. Fenel, and Mr. Vishen. I'm sure they will be kind enough to pass on to me. And whatever message I receive as your comment, as your feedback, as your questions, I'll make my endeavor to address those issues as we go along. I have a small presentation with you, but since this presentation was something which I was just writing it. In fact, it was work in progress when Vishen called me and I shared with him. So there may be some points which will not be elaborately discussed, but I'm sure we can always go beyond that. That's only a start. That's a basic point of discussions. And I'm along with the friends, I think. I'm a chartered accountant myself. Whatever little I have in my life today is because of being a chartered accountant. If I was not a chartered accountant, I would not have been appearing before the tribunal. If I was not appearing before the tribunal, I would not have been. I would not have thought about becoming member here. I'm a member here because they have an institution of accountant member, and then of course promotions take place. So I attach huge importance to my association with the institute. I attach my huge importance to my interactions with you, attachment with you, and I can tell you that whatever concerns, questions, observations you have, I'm more than happy to talk about it. Please use the chat box, and I can give you the WhatsApp number. The WhatsApp number is, if you please note it down, so that in the middle of this, if you have a question to ask, you can always send me the question. And the WhatsApp number is 8650 693355. I'll repeat that, 8650 693355. I assure you that any messages you send will be promptly deleted, and I'll not take the names, if you so wish, during when I answer these questions. Please feel free to send any WhatsApp message you want with respect to this presentation at any stage of these discussions. So can we go to a next slide, please? The first slide, in fact. Yes, thank you so much. Now, when I think of the tax litigation, what exactly comes to my mind? There are various ways in which you can be associated with the tax litigation. First and foremost, as which I believe as a younger estate, which will be very important to you, is providing litigation support services. Some of you will be quite surprised when you read this sentence, because not many of you even know that this is something which exists. But I can tell you with my practical experience and knowledge and the information I have, that at a large number of places, particularly in the larger cities, now even well-settled litigation firms are outsourcing some work with regard to litigation support. Of course, the number of people providing these services is so low that not many people know about this. And this comes in three possible ways. One is when you work as a researcher, when you do the research work. Second, when you do the documentation support. Third is, of course, a way where you are not engaged by the litigation firms, but when you are engaged with the client as a briefing counsel. Now, when you think of the work as a researcher, this is the initial and the first stage of litigation support work. That is the stage in which you do your groundwork about finding out as to what are the legal developments and what is the judge-made law on the subject. When I say judge-made law, please understand that law has several sources. What you read in the statute is only one of them. When you read Income Tax Act, you are looking at the statutory source of law. But then these provisions get interpreted from time to time. These provisions get interpreted by forums like my tribunal. These provisions get interpreted by honorable courts above, the constitutional courts like Honorable High Court, Honorable Supreme Court. Some of these provisions are read in a manner which is not what somebody would imagine at the first sight. If I can say so, these are diluted by the judicial ruling, or sometimes they are made more aggressive by the judicial ruling than they are intended to be. I'll just give you a couple of examples. For example, when you read, something like as elementary as 40AI, when you say if you have not deducted tax at source, this, it cannot be allowed as a deduction. But then subsequently an amendment is brought, let us say from year 7. But then some court reads it, they say, no, it can't be from year 7. It is to be relate back to the year 1 when the original provision was introduced. So in the year 1, somebody says that disallowance will be made. In the year 7, he says, no, disallowance will not be made if you have paid taxes on that, because if the recipient has paid taxes on that. Law is made effective from year 7, but then it is interpreted to be applicable from year 1. So when you read the law, in the sense when you read the Income Tax Act, you will not find that provision, because provision says something else. The way it has been read by the honorable courts above and by the judicial forums is a different way. So that's how I say law on the statute and law on the judge-made law are sometimes at variance. They might seem to be at variance. So that's one area. I give you a very crude example, but then there are many fine points about it. For example, let's say if you go back to 1969, that was the time tribunal did not have the powers to grant a stay. Now we all know that the powers of the tribunal are given in section 2341. But then the Honorable Supreme Court in Muhammad Kunni's case, they said, no, when you have the powers to hear an appeal, you have all ancillary powers. And their lordships read the judgment in a way, their lordships read the section 254(1) in a way that they also realized that they also held the tribunal has powers to grant a stay. So these are the examples of saying how the judge-made law and the statute law are to be read together. As a researcher, you have to update your the position, and you have to synchronize what did the law say, statute said, and what are the subsequent judicial developments. There are occasions when it can be other way also. Take for example something as simple as this: if you don't file the return and you and your tax dues, let's say nil, or let's say tax dues 500 rupees, there should normally be no prosecution. But there is a judgment by some court which says no, Whatever the amount comes later, that we'll see at a later stage. So as on the time of the prosecution, if you have not filed the return, please, prosecution proceedings will be taken. So the reason I'm pointing it out is, as a researcher, you have to understand how the law is to be read and how the courts and the judicial forums have read it from time to time. This is the basic, this is the basic work. Unfortunately, today, on many occasions, the work of researcher has become a work of somebody who goes on the computer and says cases before Pramod Kumar. Arey, Pramod Kumar ne isme kya kya dikhaya hai, dekho. Well, he'll find out the case laws, or he'll say, okay, it's about section 271B, 271B command, and let's see what are the cases which have come out. I would think that the actual work of a researcher is much more than that. He has to understand this on the first principles. He has to understand how the courts above have viewed it, and much more important than all these things, he has to understand the possibilities of how the courts and judicial forums may interpret this in times to come in the light of his past experience. When I say his past experience, means past experiences of how judiciary has intervened. So as a researcher, you try to you understand what the law is, and then you supplement that with what the judicial forums have said about it, and going by these stands, what could possibly be a legal proposition which might meet acceptance. Now, after you spend some time in the profession, like I said, I've been here for 37 years. So 37 years is a pretty long time. All this becomes a very kind of a subliminal process. You don't even realize that you do it every day. You think when I think about a section, probably I think about the section, and I also think about the developments which have taken place so far, and probably I also try to imagine as to what are the possible ways in which this may turn to be in future. So as a researcher, you could always do this work. Now you would ask me, why would a researcher do it separately? Why can't the lawyer who has to argue it will do? The answer is this: generally, by the time you are successful, and when you are successful, you are so successful that you have to invariably delegate. If I'm an arguing counsel, I would not find it productive enough to do entire research myself. The basic research is done by a person who is someone other than the arguing counsel, and then this research is placed before the arguing counsel or the person who takes call about it, and with his experience, he tries to find out as to what is acceptable and what is not. He tries to think. And obviously his understanding is much more. He does not only know the basic provision and the judicial interpretation, probably he also knows how the judges would react. If he is, for example, in Bombay, in Gujarat High Court, he thinks, oh, bench is this bench will go this far, so this may not work. It's a good idea, but it may not work here. We'll try it some other time. So we'll use this. So as a researcher is the first stage, and I can tell you that 9 out of 10 chartered accountants, when they go to the litigation field, initial stages, that's how they start. And that's where they prove their worth also. That's where they show, look, I'm different from others. This is what I can do better. As we go along, we'll also see what precautions, what it takes to be a good researcher. But let me move on to the next point. Next point is documentation support. This is something which I learned only very recently. I know of a very large firm, somebody who's fairly successful. They have outsourced a considerable portion of their documentation support to a firm based in a non-descript tier 3 city. This is where you do the documentation part. When you do the documentation part, it's not only the grounds of appeal and statement of facts are probably not on the back of my mind, collecting the material, preparing the paper book, sometimes even writing the written submissions. So in many cases, people outsource it for a variety of reasons. Some of the reasons could be that these could be the areas dealing in, for example, niche areas of transfer pricing, where not many people are comfortable, although they are very successful firms, but they think it's something which they have not learned in their youth. So they would expect someone else to do the groundwork, or they don't find it worth it to engage their expensive staff in this work. So they have the documentation support, and the documentations, whatever documentation is done, then again it's vetted, part is retained, part is discarded, but that's a support staff. In many cases, it's being outsourced. As I said, I know of one firm in Bombay, and my first experience of this was way back in 2002 when I learned that a Calcutta-based firm was doing it. And they were, of course, using retired commissioners, and they were giving them a fixed amount that, look, these are the papers, this is the case. You develop the case the way you want, and prepare the documentation to us. That's also a possibility. Third is as a briefing counsel, litigation support services. I can tell you from my own experience also that many senior lawyers, they don't accept the briefs directly from the client. They want them to be briefed by a chartered accountant for a variety of reasons. Of course, one reason is that it's easier to deal with them. It's easier because they understand, they've handled it at the lower level. They understand what are the nuances because they've been handling the client, so they know what has to be done. And on many occasions, as a briefing counsel, we find it much safer also. For example, I can tell you a very recent experience I had about a few weeks back. A few weeks back, I was talking to a friend of mine who is now heading a large PSU in Delhi, and he was telling me that he has engaged so and so as his tax consultant. So I said that, why did you pick him up? I was mentioning some other names. He said, no, Pramod, because every person I talk to, he had a different name in mind. And it depends on, which person is to be hired at which stage is the call to be taken, depending on what the case is, depending on what kind of case it is and what kind of forum it is. So I can't engage an arguing counsel as my retainer. I need my retainer as a chartered accountant who would probably help me decide who's the best lawyer to be taken for which case, for whichever case. And that came as a pleasant surprise because I was talking to a person who has nothing to do with a law or accountancy. And he also realized he's basically an engineer who got into civil services. And he said, no, when I have to take a call, I want somebody to tell me which counsel is suitable for which case. And I don't want everybody to, all these cases to be dealt by one counsel. So that's another area. And I myself, when I was in my years in practice, and the first break I got was of the Indian Airlines way back in 1992. So I was a retainer for Indian Airlines, and Indian Airlines had a large number of lawyers who would engage for a variety of reasons. Those were the days of Congress governments. There used to be so much of politics that you have to keep X in good humor, we keep Y in good humor. You have to give this case to Z because he's so and so's man. So, and we used to, we used to get instructions that, in this case, we have to hire so and so, and of course they would ask me. And my job used to be, I'm talking of my early days in profession, my job used to be to first of all assess what kind of person we should hire, and then to assist the management in taking a call and who should be the counsel who taken into account. But nevertheless, my client would of course insist that I'm always involved, and my job there used to be as briefing counsel. And that's how I started coming to tribunal in the large cases. I started coming to the tribunal in large cases in my initial days only because the persons whose cases they were my clients, and those clients of mine had their cases, and they would want me to be involved at each stage of the litigation. As a matter of fact, even when the matter goes to High Court, they would expect me to take a look at this. So as a briefing counsel also, it's a litigation support service, but the difference in the first two category and third category is this is a service you give to your client, not to the to an arguing counsel. Then second major step is courtroom frontline warrior as an arguing counsel when you present your cases. Of course, that's where when you think of the litigation career, that's where most of us visualize ourselves to be. Whatever be the level of the appellate forum or the forum, you present your case, you argue out your case. It could be before the Commissioner of Appeals, it could be before dispute resolution panel, it could be before the income tax appellate tribunal, or it could be before any of the forums where chartered accountants are permitted to appear. So, but then your job there is, I use the word frontline warrior because in the COVID days, everybody talks about the frontline workers. So we learn from what's going on around us. So frontline warrior is a person, for example, when I can tell you from my experience, when I hear a case in the courtroom, I have one person before me arguing. Take for example, taking names isn't appropriate, but nevertheless, you to give some name just for examples. Let's say if a case gets argued by Mr. Soparkar, then you know when you look at the file that this case is being argued by Mr. Saparkar, but Ernst and Young is the company which has engaged him, and then you also see 3-4 persons who have been briefing him, who have been telling him what is to be argued, what is not to be argued. Whatever Mr. Saparkar speaks, he speaks for the entire team. And no matter how big a council you are, most of them, I would say all of them, are gracious enough to mention this and talk about this, that more often than not, those, many inputs come from the team. So those are the faces of the team. Similarly, you have some in-house teams in many forms. So they take Mr. X or Mr. Y who actually presents the cases. The work is done by the entire team in different capacity. But here is a person who argues it, who stands up, who takes the responsibility. He's the leader, he's the lead counsel, and probably he approves the strategy to be followed. He approves the path to be taken. He approves what documents are to be filed. He approves the line of arguments, and then he actually delivers it. And probably the most challenging part is when he has to face questions, from from the benches, whether from the Commissioner of Appeals or from the DRP or from the ITAT or whichever forum it is. And that is the most visible and most glamorous part, I would say, of being being in the litigation career. And I can tell you that we have a very, very large number of chartered accounts in all stations. Of course, Ahmedabad is one of those stations. Mumbai, Delhi, every place I've been to, Calcutta, where you have a very large number of chartered accountants who actually play this role, and they play this role so well that it is impossible to find out or even demarcate between a lawyer and a chartered accountant, because they do exactly what a lawyer does, or probably lawyer is expected to do, lawyer is seen as doing in the courtroom. So you are the courtroom warrior. You are presenting the cases. You are, deciding the strategy. You are meeting those challenges. But then remember, these are the things which come to you with passage of time. I've seen brightest of the youngsters in the initial stages, and then gradually they start. When they start their careers, your first time you go there, you just ask for an adjournment, and then then also you have all butterflies in your stomach. This is nothing new. It happens to everybody. But then, as the time passes, as you become familiar with the system, as you become familiar with the system, as you become familiar with the members, and as you develop more tolerance, I mean, you have more patience. And I often, this reminds me of something. When I was a young student, and I was a young student long ago, I'm in my latest in the fag end of my 50s now. So you can imagine. That time I used to hear from my earlier generation that there used to be a question or an arithmetic, and question was something like this: that if the water is flowing in from the tap at the rate of X liters in a minute, and there are 3 holes in the bucket, hole 1, which loses Y liters in a minute, hole 2, which loses Z liters in a minute, and hole 3, which loses A liters in a minute, then calculate in how much time the bucket will be filled. And then you have to work out at what rate the water is flowing out, what rate the water is coming in, what's the difference, then divide it by the time. This used to be as simple a question as this, and I used to ask myself, what a stupid question. Why do people ask these questions? First plug the holes, then fill the bucket. What's big deal about it? But today, having spent almost 60 years on this planet, I can tell you that these holes will never be filled. And yet the challenge is how to fill the bucket. And why I'm telling you this is that when you're in the direct tax litigation practice particularly, you will have many moments of frustration. Many times you'll say, what nonsense is this? Why can't we do it? Many moments of sheer frustration when you start losing your patience. But the maturity is how to handle those weak moments and how to handle the imperfections. We talk about this a little later, but then as an arguing counsel, I think this level of maturity, this is what is needed, and that's the most important, most visible and most glamorous part of the tax litigation career. Then there are 2 more points which are a little interesting. And first, for example, I mentioned about performing judicial functions as a member of the appellate tribunal and on conciliation board in times to come. I'll explain that. So, as far as being a member of the tribunal is concerned, I'm one of, one example. As I said, I'm a chartered accountant. Even till today, I do not have a law degree. I'm still, as a matter of fact, I'm a student of law now. And I'm working as a de facto judge for last 2 decades. And that is because that has been possible only because of being a chartered accountant. Of course, I graduated from all these stages. I did the research work, I did the documentation support, I was a briefing counsel, then I got an opportunity to be arguing counsel, but that was not for long. Just as this started, I was picked up by the tribunal. Then this is something very unique about the ITAT. ITAT, for your information, and I'm sure you must be aware of this, is one of the oldest tribunal in India. Not one of the, it's the oldest tribunal in India. It was set up way back in 1941, and in the British days, this was first brush of India with the tribunalization. And this is the only institution where you have a chartered accountant on the bench in equal capacity. As a matter of fact, you will find chartered accountants heading the benches, heading the zone. I'm before you. I'm heading Mumbai zone now. It's considered one of the very important zone. I had the privilege to be in Ahmedabad zone for 4 years. So they come, they are, each bench of each division bench of the ITAT consists of 2 persons. One is a judicial member, the other is an accountant member. The judicial member is either a district judge or additional district judge with specified years of experience, or a lawyer with 10 years plus experience. And an accountant member is either an IRS with an additional commissioner and above with 3 years experience, or an IRS or a chartered accountant with more than 10 years experience. Every couple of years, you have this selection process. As people retire, people get selected, and once they join the tribunal, they become permanent employees of the government. I'm here for 20 years and I have some more years to go. And they are given equal treatment in the sense that there are tribunals, for example, company law tribunal, where I'm told technical members can never preside the bench. They have to play a secondary role. But that's something which is happened in the ITAT. We are not only heading the benches and zones, but there have been accountant members who have been presidents for a long time. Mr. Krishnamurthy was one of them. He was the longest serving accountant member who headed the institution. And it is something I can tell you that it's not as difficult as people think it is. Once your focus is right, once you are planning your things correctly, and even if you don't have a tax practice, I know of many of my colleagues who do not come with a very prosperous tax practice. Many of them did not have a tax practice from different backgrounds. But as long as you keep yourself updated, as long as you are willing to face that interview and meet those norms, it's really possible. But of course, it comes at a later stage. The minimum they expect is you to have an age of 35 years and 10 years of experience. So practically the earliest you can join is at 37, 38. But then it's possible. You can look at it as a career. Some people see it as a progression. As I said, I'm one of them. I have my colleague, Brother Gst who's in Delhi benches. He's another. My another colleague, Brother PM Jagtap. He's in Calcutta benches. He's heading that zone. Brother Pannu is heading his zone. And they are all chartered accountants, and they are the ones who came from practice. We have another colleague of ours, Mr. N.K. Saini, who's heading Chandigarh zone. He's a chartered accountant too, and he was in practice like all of you or most of you. And then he came to the tribunal. He made it a career. I made it a career. I have no regrets. I mean, that's one of the possibilities. So, and this is the only way probably you can be performing judicial functions. You are de facto a judge. You are doing exactly what a judge does. And I'll tell you something interesting. I was director of the International Association of Tax Judges, which is set up by Gst Course of Canada, headquartered in Amsterdam, and I was on their board of directors for 3 years. And who were my colleague, members on that board? Chief Justice of the Gst Course of Canada, a Supreme Court judge from Australia, and I was probably only non-lawyer to become a director of the International Association of Tax Judges. But I could do it because of being a chartered accountant, and that's what I'm telling you today. That if you think of tax litigation as a career, please think of this option also. This is an option. It's a serious option. And of course, it needs you to prepare just as you prepare for exams or prepare for everything else in your life. Then I mentioned about the conciliation board in times to come. That's interesting. That is, what has happened is that you were aware that there was a tax simplification committee which had filed a report. And as a matter of fact, they are also they prepared an alternate income tax act, and this report somehow never came to the public domain when Honorable Finance Minister took over for whatever reasons. This report is still under consideration, but she decided not to let it go to public, and it is still. Of course, unofficially, not many people would have seen it. If I have seen it, I'm sure others would have seen it too. People know about what's in this report. People know about what are the recommendations in the report. And one of the interesting recommendations is were about the conciliation boards. As a matter of fact, me, along with Honorable Justice P.P. Bhatt, President of the ITAT, we had gone to the simplification committee. We ourselves argued that we have to involve the professionals in some way for the conciliation work as a part of the ADR mechanism. This conciliation work is at a stage, for example, when some litigation goes to an appellate forum says, no, please think of the conciliation. So it goes to a conciliation board. That's what the scheme is. And this conciliation board has a large number of people coming from different streams. Our suggestion was, and this suggestion was, as I said, I was part of the team which made the suggestion. And the CBDT was gracious enough, and they have been gracious enough to accept it in some way. But as the report is not yet implemented, we do not know what shape it will be. But our suggestion was that chartered accountants, after a certain number of years of experience, can be taken on those conciliation boards as a part of what you call arbitration exercise. As a part of conciliation board, when we can decide, we can reach midway and decide what to accept and what not to accept. So this is a possibility. This has happened. This is not on the statute today. But once these things come in discussion, I'm sure it's only a matter of time when these things become reality. I do not know what is the exact number of years which will get approval, but we had several patterns to work on. One pattern was, let's look at 15 years. Like they said, let's look at the chartered accountants who have retired. Then there was another option was, let's look at the youngsters. So I do not know what form it will take place, but I'm sure it's only a matter of time when some mechanism of the ADR in the form of a conciliation panel, conciliation board, or whatever you call it, has to come into the tax adjudication. And that is where I'm sure those of you who have good exposure to the tax practice, taxation, nuances of taxation, and those of you who are willing to make a career out of it, maybe you have something about arbitration or something of that sort, they may have a role to play in this, but that's something which is still hidden in the womb of future. We do not know what exactly the shape will be. But then, as I said, we all try to anticipate what the future holds for us and prepare for it accordingly. That's one idea. Then the last point is as a domain expert or expert witness. Now, domain expert or expert witness are more or less the same thing. But this is one thing that we have been toying with for quite some time. As a matter of fact, in Ahmedabad benches, I tried it once, but unsuccessfully, when we thought of calling an expert witness outside for examination before the tribunal. I can tell you abroad, it's a very common thing. In India also it has happened. It's not that it hasn't happened. If you read the Azadi Bachao judgment, you will find that Mr. Baker appeared there as an expert witness. And in many occasions, courts have depended on the expert witnesses. If you see the functioning of the Tax Court of Canada, then you will find expert witness has an important role to play. And if there's judgment, for example, which you can read, that judgment I would think is the Glaxo judgment, Glaxo by Tax Court of Canada, where you will see the proceedings. And talking about it at Tax Court of Canada, it would be interesting for you also to look at some judgments which are delivered abroad, and then you will see some trends in those judgments. And the expert witness or domain expert being called to assist the benches is one such trend which I saw in the Tax Court of Canada first. Of course, these are the cases where high stakes are involved. These are the cases where complex cases are involved. But then certainly that would be one area. And my take is I'm being futuristic. I'm trying to visualize what will happen 5 years, 6 years, 10 years from now. But I'm sure expert witness will be one area which could see its presence in India in times to come. So that's one area it may prepare you for. Can we go to the next slide? These are very small slides. Thank you, Bishan. Now, what is that? What is that you need to be a good to have a good career in tax litigation. First of all, you need passion for litigation work. There's absolutely no substitute. If you don't have passion for litigation work, please, there's no point in coming here. You have to be extremely passionate. And I'm saying this for the reason because there will be times which will be very depressing and frustrating times. There will be times when you will need extraordinary patience. There will be time when you will have to convince yourself that no, it's worth it. It's worth taking all the weight. And that is possible only when you have the real passion for litigation work. You must have a flair with the language, spoken as well as written. I would think in the initial stages, it's really important that you are able to draft your submissions well. You are able to you are able to use the language in a manner which conveys your things in simple words. Please understand when somebody like me reads an appeal or the paper comes to me, I have only those papers. I only read what is written on that. I do not know what else you know. And unless you are smart enough or capable enough of conveying to me what needs to be conveyed, and you are able to hold my interest, it doesn't work. Now, how do you hold my interest? How do you convey that? That's language. You need to have a command in language. It doesn't mean that you need to be a huge debater or something of that sort, as you see in the filmy scenes, that something dramatic about the courtroom. No. I mean, that's not the idea. These things are not in the real life. In the real life, what happens is you have to be soft spoken, of course, but you must have the flair for the language. You should be well read. And I tell you, the other day I was addressing a WIRC conference and this issue came up. Some people complained that today youngsters don't have that command on language. As to why does it happen? There's only one way to have command. That command is read and read. I mean, you have to read the classic literature. You have to read the good books. You have to read judgments of the people you think they are readable. Just don't read everything, and you have to learn from them. You imbibe from them how it needs to be expressed. Articulation is an absolute must. And of course, it does happen that not all of us are gifted at equal level. Some of us may have some issues. But then, please believe me, that with the passage of time, if you just read and read more, write and write more, rather than talking in general words, get into specifics, you can always improve. And as I said, of course, you can read the classic books, you can read good books, but there's also a way. You can read good judgments. Identify the judges you think write well. For example, Justice Akhil Qureshi. I mean, I'm a huge fan of the Honorable Justice Qureshi. The way he writes, I mean, I wouldn't go into other things. There are things one may have issue with him, but I'm only talking of one facet. One of my seniors, Honorable Justice Ishwar, who was later the High Court judge in Delhi, and he was a very distinguished member in the ITAT. I had the privilege to be with him on the bench, and he was our president also, and he was posted in Ahmedabad for some time. An extremely gifted person. I mean, the way he puts it, absolutely amazing. So you have to, if you really want to be an Ishwar, then you have to read what Ishwar has written. You have to see how it goes. And for example, I don't want to take names of the persons who are here today, but then you have to see. Mr. JP Shah is no longer with us, one of the most illustrious senior advocate we had in Ahmedabad. But his way with the words was absolutely amazing. It's absolutely amazing. It was a treat. If you hear these people, he's no more, of course, but I can't take names of the people who are in practice now. But it wouldn't be difficult for you to identify them. Hear them, and today you have these webinars, you are flooded. You have anytime you go on the net, you can go to the YouTube, you find hundreds of persons. Hear the persons who think they are good. Read the persons who you think write well. And then write as much as you want. Practice as much as you want, but you must have very good command over this. That's one thing. Second is patience and tolerance with respect to systemic weaknesses. This is a difficult job. This is a difficult job. I know sometimes you think, oh God, I filed an appeal, nobody is listening, I moved the paper, this is not happening, I'll go to the courtroom, matter gets adjourned. You have to have tolerance. You have to have tolerance. There is no substitute to it. I'm not saying that you tolerate it in the sense that you don't take remedial actions. Take the remedial actions, but don't punish yourself with the fact that these things haven't gone your way. You have to become detached about it. It's easier said, but then that's all you can do. If you don't become detached, there's nothing else. You will only punish yourself. There are so many things. We don't live in an ideal world. Please don't go into litigation if you cannot tolerate a less than perfect world. The judicial system is not perfect. Sometimes you get frustrated with the judges. Sometimes you say what members we have. Sometimes you say what commissioner is doing. He's not listening to me. It's such an open and shut thing. But then be tolerant. You accept it as a part of the system. If you cannot accept it, litigation is not for you. You have to accept people as they are. They are the package deals. In litigation system also, there are some good things, there are some bad things. If you think, no, I can't accept the bad thing, I will only take away the good one. No, it doesn't work. It doesn't work. Then your office is the best place where you can do some chamber work and you don't have to deal with people. And then highest level of objectivity in thinking. When I say highest level of objectivity in thinking, all I'm saying is the day you reach the ability to criticize yourself, then you think you have arrived. The day you develop an argument and you say, my God, what nonsense argument is it? Then you think, yes, now I can take it. And I can tell you, by now I have written more than around 15,000 judgments. There are occasions when I read my judgments and say, oh God, how could I write it? It does happen. We are human beings. We evolve every day. We make mistakes. We learn from our mistakes. But you need to have that objectivity to understand that you should be able to appreciate both sides of a situation. And when I talk of this, I'll give you my own life lesson. Way back in 1994, I was briefing one of the very distinguished senior advocates in Mumbai. It may not be appropriate for me to take name for obvious reasons, but he's a legendary lawyer. He's in practice even today. Of course, with his passage of time, he doesn't come as much as he used to come 25 years ago. And he's a very, very learned lawyer. And those were the days when Bombay-Delhi flights were either in the morning or in the evening. And this senior advocate used to give me time of 2:30 p.m. So that means I have to catch flight at 8 o'clock in the morning, kill my whole day in Bombay doing nothing. And at 2:30, I have to be outside his chamber to do my briefing session. After 3 rounds of briefing, this gentleman said, he looked at me and said, you have no case. I said, but sir, he said, no, Pramod, it doesn't work like this. What nonsense is this? The case was with regard to some employee allowances and tax deduction liability. He said, what is this? You are giving them chaddi allowance, banyan allowance, and you want somebody to believe that this is actual reimbursement? It just doesn't work. And this legend of tax laws is a man of few words, at least in his chamber. So after he said you have no case, he was quiet. There was a deafening silence in the chamber. And as a youngster, I did not even know how to react. I did not know. I mean, I said, my God, I've been coming here for so many days. My client has already spent so much of money on me, and now this counsel tells me he has no case. How do I get another lawyer? And I asked him. I said, sir, then whom do you recommend? He said, what? I said, then which lawyer do you recommend? I said, why should I recommend a lawyer? I said, sir, you said you have no case. And he said, no. Listen, I am saying you have no case. But all I know is that in ITT Mumbai, you might be able to get relief. If the matter goes to X, Y, and Z, you will get knocked out of the courtroom. You have no case. They'll just throw you out. But if the matter goes to A, B, and C, 99% this case will go past. I was taken aback. So I said, sir, what happens if it goes to X, Y, and Z? He said, of course, we'll argue. We have the support from 140 ITR. We'll see how far we can take Gwalior Range case. So we'll see. I think we'll see. We'll take it a chance. And then he added the words which are as fresh in my memory as my memories of today. He said, Pramod, I'm a lawyer. I'm not a professor. I'll argue for you, and there are good chances that you might win also. But tell your client that these practices don't work. You have to pay the allowances actually for reimbursement, not these stories. Now think of the postscript is that this matter got argued. I had the privilege to assist him in the courtroom, and we won the case. It's a reported judgment, 59 ITT 353. It's a reported judgment, and that was my first appearance in Mumbai Tribunal. We won the case also. High Court also we won as justice history. But think of that lawyer for a minute. He says that you have no case at all, and yet when he was in the courtroom, and I can tell you from my memory, this man was so aggressive in the courtroom. He said, "What have you? I mean, where have we reached? What kind of orders are being passed?" And how aggressively he argued before the courtroom is something unbelievable. There is so much for us to learn from that. We need to have that objectivity in thinking. We shouldn't become so involved that we think, no, whatever my client has done is right. When you're dealing with a client, tell him the truth. When you're talking to the bench, then you do whatever you think is proper. Of course, within the norms of decency, within the norms of scruples. But you can, I would say, you can argue whatever proposition you want to argue. But you should be so detached with that proposition. You should be so much objective that knowing fully well what it is, you can say, even if I lose it, it doesn't really matter because I know it has no case. So that is the level of objectivity in thinking which is required. And I'm not talking of the maneuvering. I'm talking of objectivity in thinking, your ability to think what's right, what's wrong, what's correct, what's incorrect. Purely clinical thing. It's like you have you give somebody a cut, but not more, not a millimeter more than required. So that's one thing. Domain expertise, of course, is absolutely essential. You have to be good in this. But then domain expertise and being successful chartered accountant are not necessarily the same thing. Success has its own recipe. Expertise has its own limitations. Of course, when these things blend, nothing works like this. But there are occasions when they don't follow the same path. Please have the expertise. And when I say expertise not with regard to the every provision. Expertise with respect to what is hot, what are the emerging issues, what is new. Try to understand more and more about it. Read about it. In the next few minutes, we will also see what could be the sources. Absolute integrity in conduct, and that is absolutely non-negotiable. Your integrity in conduct is the biggest thing that can help you in the career. Yet, ironically, this is the most ignored thing in the modern days. Just think about it. Every day when I interact with people, every day when I decide cases, I take calls, and my colleagues take calls, and of course, honorable courts above and their lordships in the courts above take calls, involving thousands of crores. You hear all sort of ugly stories about what goes on in this world. But what is this that gives you faith that here is a case in which I can stick my neck out? That is when you know that he is a man of integrity. He wouldn't do anything. He wouldn't take a shortcut which can put me into trouble. So it's your integrity which really matters. And integrity is not only in terms of, I would say, money. It's in terms of your conduct. Because, the way you carry yourself, don't get involved in the light talk. Don't get involved in, for example, sometimes criticizing people is big fun. We do it all the time. Don't get involved in the light talks. We can remain confined to your stuff. And that is the integrity that integrity is intellectual integrity, this is financial integrity, this is behavioral integrity, this is human integrity, this is integrity about respect and love that you have for people and not having contempt for people. But that is important. And that is something which comes from good values. No damage done. It may so happen that by now you would have seen the world from a different angle. The way you have seen your initial years doesn't matter. Any day you decide that now onwards I will not take this nonsense, that's the beginning. So don't let your past, even if there is any past, become a burden on you. You have to be even today you can say, all right, I may have done it till yesterday, but right now on I won't do it. I won't get involved in light talks. So that's it. Ability to deal with people. And ability to deal with people is, of course, a very, very important thing. You have to be polite but firm, and dealing with the people doesn't really mean getting friendly with the people. Please don't mix up the two things. These are the things, everything you do must be with a purpose. And that purpose must not be lost. That purpose is when you are dealing with human beings, some human beings will be imperfect. Some people will not turn up on time. Some people will miss the deadline. Some people will say that we'll start the webinar at 4 o'clock until 4:30. They'll be talking about things which do not interest you. Some people will promise you talking about the litigation in career, and they'll give you their own stories, but be tolerant to them. Once you have this ability of dealing with people, getting the best out of the people, and remember, the same person can be good to someone and bad to someone. There are people who have done of the worst of the crimes, social crimes, or maybe other crimes, but then there has been a good side to this also. I don't know whether you read it or not. In our time, there used to be a story written by Robert Stevenson, Dr. Jekyll and Mr. Hyde. And this is a story about Dr. Jekyll, who was a gentleman, and he used to take some medicine, which was intended at highlighting the characteristics of the person, and he would become a bad man. And when he becomes a bad man, he doesn't want to become a good man again. And this is a long story, some other day for this, but something you can Google. This is if you have not already read it, it's Robert Stevenson has written it. The story is set in 1800, and it's called Dr. Jekyll and Mr. Hyde. Why I'm talking about this is today, everybody has a Dr. Jekyll in him, and everybody has a Hyde in him. It's on you on which side you invoke. When you are good, people are good to you. When you talk about good things, when you decide to ignore that dirty word, which is, even if it exists, you don't care about it, and you're nice in your conduct, people are invariably good to you. And once you follow the wrong path, then it's very difficult to come back. They always see you in that light. What happens is, whenever you interact with a person, your first impression goes a long way. I can tell you my own experience. When I was in Mumbai in my first round, I wrote some judgments on the international tax. I mean, for me, those judgments were just like other judgments I wrote. But those were the years when not much was being written about international tax. International tax was so much tagged with me that people would only talk about international tax when they talk about me. I said, my God, I know little more. I know about the Income Tax Act also, but nobody would listen about it. They'll say international tax transfer pricing. So when I was writing Canbase software, a decision on 271 1C penalty from Pune benches, and people said, "Oh, Pramod, you wrote an excellent decision on penalty." I was so relieved. I said I could at least remove the tag. But then today, think of the another story. Today, think of how the tags get attached. Whichever side of you gets noticed initially, that is the side which will probably hold for long run. So when you are good to people, when you are dealing with them nicely, ethically, fairly, and your good side is known, that will always help you. Okay, let's move on to the next point. Now, what is the nature of litigation process? Can somebody help? Can someone? Yeah, thank you so much. Now with this long, lengthy background, let's go on to what is the nature of litigation. What how does it happen? Now, let's say your client receives an order that he's aggrieved of. Then what do? Then first thing you see is, of course, first thing you see is how much is the tax demand and when to pay this. Keep that apart. On a conceptual note, you see, when you are to litigation side and you are thinking from the lens of a litigation expert, the first thing you see is all the procedural requirements are complied with or not. You think about what are the process involved. Is there a breach of process? And this breach can take place in any way. For example, if somebody imposes a penalty on you and there is no initiation of penalty in the assessment order, that's a breach of process. You can't impose the, or let's go a step further. Let's say somebody imposes penalty on you on item A. Somebody makes a quantum addition on item A, goes to Commissioner Appeal. Commissioner Appeal removes that ground, puts some other ground and makes the addition. In the meantime, so instead of an addition of 5 lakhs, this becomes an addition of 10 lakhs, but on a different ground. In the meantime, assessing officer, the moment it comes 10 lakhs, he imposes the penalty. But then you say, who initiated penalty with respect to what? So you ask yourself, is the procedure complied with? If somebody opens the, sort of reopens the assessment, then you ask yourself, are the reasons recorded? What are the reasons recorded? So then you look at all the procedural aspects. Are these done or not? Then you look at, is there a gross violation of justice at some stage? It could be a violation of natural justice. It could be something so blatantly unreasonable that you think it can make out a good case in the appeal. That's fine. Then you see, is it how the related provision, then you see gross violation. Then you think, in the best possible scenario, how it should have been interpreted. As I said, we don't see the provision itself, you see how provision is to be interpreted. And that's what you realize when you read some of the judgments which have narrowed down or broadened the scope of the provisions. Then you realize what happens to the taxpayer in the best possible scenario. And then you think about to what extent can you correct the situation, and what is the likelihood of getting it, what are the costs of getting it, and what is the time frame of getting it, what is collateral damage. The collateral risk I have said here. So collateral risks are, for example, if you go on a very trivial issue to the Commissioner appeal and you know he has full powers of enhancement, this is a huge collateral risk. When you, for example, if there's an X addition was required to be made, then you take a call whether I should take it up in further scrutiny or not. Can I get into trouble by taking it to further scrutiny? And then you realize that what's the chances of getting success? Then you realize at what level will I get success? Do I move 154? Do I move appeal? Or will I have to go to the tribunal, or tribunal decisions also against me? I'll have to wait till the High Court. Then you think of what are the costs involved. If the amount is so small, if a 40 AIF disallowance amount involved is 80,000 rupees, you think what will I do with 80,000 rupees, or even 8 lakh rupees? Is it worth it? So you think from those angles. Then you think of the time frame. What is the time frame that you are looking at? And then once all this meets the count, meets the test of approval, then you determine, then you identify the questions which, if decided in your favor, what are those questions which, if interpreted in a particular manner, can tilt the things in your favor? And you keep the appeal with that focus in mind. You know, when you start an appeal, you may have several things to think about, but then you have your main focus is on this. Your main focus is this is the question on which I'll win. So with this thing in mind, I'll write what I have to write. Then it's also important sometimes at what stage do you want to open your arguments, open your cards about all the arguments. Sometimes you realize that going into 154 doesn't make a sense. For example, if the other day someone was asking me a question. He asked me about something. I'm sorry, I lost the thought. I looked at this and I was saying, yeah, this was a question about FTS, about fees for technical services, and the argument, the ground on which the disallowance was, it was treated as something on which tax ought to have been deducted, was on the point of who is the beneficial owner. If he was to rake up, that aspect was probably something going against him. But on the technical aspect taken by the assessing officer, things were all right. Things could have gone with him. But the risk involved was that if you open this issue in front of the Commissioner appeal, he'll make it up for it and it's finished. Technically, you are right, but it doesn't make sense to take up this argument here at this stage. So sometimes you take 10 arguments, concentrate on the 9, take the 10th also, and wait for the right forum for that argument adjudication. Some, invariably trouble in most of the cases. So you also have to take a call at what stage you have to open all your cards. And then I said, can we have a parallel litigation on what needs to be adjudicated first? Which needs to be adjudicated first. I'll just give you an example. The same example which the case I was talking about. We were dealing with a case in which some airline crew members were given huge allowances, and these allowances were stay-over allowances, layover allowances, breakfast allowance. Breakfast was called light refreshment allowances, overnight allowances, and all these allowances were treated as a reimbursement on the basis of some clarification which was issued way back in hardly, I think sometimes in 80s during Rajiv Gandhi regime, because he was also a pilot. So somebody could get a circular saying that look, all these allowances are in fact reimbursement of expenditure. Therefore, they should not be treated as income, and they are outside the scope of income taxable under the Act. That was circular with them. In the meantime, they kept increasing the allowances, and we reached a stage where almost 60% of the Indian airline pilots' salary used to be in the form of allowances. So it was an absurd stage. So that was a time when things came to an end, and the income tax department came down very heavily on it. And income tax department said, "What nonsense is this? This is purely malified act. You are giving them salary in the form of allowances. This is not something which is done bona fide." And that time there was a very aggressive and very learned, and I would say young assessing officer who is now a commissioner appeal. I can name him, Mr. Abidi, SMJ Abidi. Abidi was a very hardworking and very aggressive young man. So he wrote an order raising demand under section 2011, read by section 192, and he wrote several pages on the malified. He said the airline has behaved in a unreasonable manner in this way, and his order was full of the pros criticizing the conduct of the employer. And he said, no, this tax deduction is absolute malified nonsense. So it is something they have to pay under 2011. They can't take shelter of 192. On 192, there was a time, those were the days there was a judgment from Madhya Pradesh High Court, if I remember, 140 ITR 832, Gwalior Rayon. In Gwalior Rayon, the court had held that as long as the action of the employer is bona fide, since 192 is only an estimation, then assessing office, then the employer cannot be held to be responsible for short deduction of tax exports. And their lordships drew a line of demarcation between the tax liability of the employee and the tax deduction liability of the employer. Their lordship's view was that tax deduction at source liability is a bona fide estimation of income of the employee. And tax liability is whatever is taxable is tax liability of the employee. So there was a thin line of demarcation between these two things. And our problem was that as this matter went to the Commissioner Appeals, we realized that we cannot come out of the allegations of malifieds. On a parallel level, because those were the days the tax deduction at source was decentralized at 5 places. At 4 other places also, this problem was brewing up, because once something happens in Delhi, they pass it on. And of course, those were the days without emails and faxes, but nevertheless, there was exchange of information. People would know about it. So then we had to take a call as to which is the case, which is the assessment in which the malifieds are not alleged. So we would dispose of that case first, that region first, because on bona fides we can go past this, and once we go past on bona fides, then the other regions will become covered by it. And that was the reason I was mentioning you about that example also. That was the reason that we took up the Mumbai region first, because in Mumbai there was no allegation of malified. So we said, all right, this is the allegation. We can, this is where we take up the issue first. यहाँ पे malified इतना strong नहीं है. This theory can work, but Delhi में this theory cannot work. So the call taken was that a parallel litigation is to be developed at some other stage, at some other station. Then we'll be in a safer area. That's one area we decide. Now moving on to the next slide. That is about the first appellate process. The first appellate process, now we talk about the nitty-gritties of what really happens. You all know that when you talk of first appellate process, we essentially think of CIT appeals and DRP. Their powers are much wider, including the powers of enhancement. Of course, they don't have power to set aside, but beyond that, their powers are much wider. It's a more informal place. It's a place where probably you discuss the things the way you discuss with your assessing officer, rather than the way you discuss with the talk about in the court. So there are advantages of this forum, and there are also disadvantages of this forum. It's informal, so I don't know how many of you have experience of appearances before the these kind of forums, but informal forum has its own disadvantages. They can take more liberties than they should be allowed to take. And then those advantages, that this is less formal, you can talk to things in simple words. Disadvantages, that sometimes the liberty that people have in informal interactions is not put to best use, and people tend to be little more liberal with whatever path they follow, whether it's their arrogance or whether it's their uh, irrelevant talks or whether it's their curiosity and the right path also. So you have advantages, you have disadvantages, and there's a popular notion, popular feeling, I don't know how true or how untrue it is, that they have leanings for revenue. So now we have read it in newspapers. I read it as much as you must have read it, that their promotions depend on how much announcements they can make. Their reputations depend on how much demands they confirm. So many people see it as a kind of necessary evil. They say they have to do nothing. If it's something open and shut, they'll give relief. Unfortunately or fortunately, this is a new trend. I can tell you from my experience as a chartered accountant. I can tell you from my experience as a tribunal member. I have seen some very, very bright and very courageous CIT appeals who have been very aggressive in giving relief where they see it's due. But as I said, you can't have a straight jacket answer for this. But then more often than not, this is usually a procedural step before the matter comes up for judicial scrutiny before higher forums. But then there are certain areas where this is a very, very important forum. For example, if it's a search-related issue, if it's a comparable related issue, it's relating to an issue where by and large law is settled, where the department has accepted it. So on those issues, this is a very effective forum. I think wherever lots of factual investigation are concerned, and you shouldn't take this forum lightly, even if you are looking at relief at some other forum, because that's a forum that's an order which will always come up for at least examination before the higher authorities. So you just can't take it lightly. You have to be very careful about it. For an extremely factual matters, this is a very important forums. But remember, they tend to be a little dismissive of the law. I'll give you another example. We all know, I was talking to you about the powers of the Income Tax Tribunal for granting stay, and Mohammed Kuni's case, the landmark case of Honorable Supreme Court, where their lordship said that under Section 254(1) we have the inherent powers of granting the stay. There are also decisions where the courts have held that since the commissioner also has power to dispose of appeal, this is also an incidental power to grant stay. And there are judgments of honorable high courts. I don't know. I don't use this side often now. I can remember from my experience till the year 2000. And at that time, if I remember correctly, it used to be Paulson Litho, tin manufacturing, where the honorable courts above had said that no, CIT appeal can grant a stay, but CIT appeal never does. I don't think of many cases where CIT appeals have granted a stay when the matters are pending before them. But then as a strategy, what we used to do, what I used to do when I was in practice, particularly in the large cases, we used to move a petition seeking a stay before the commissioner appeal. You would say, Lord, your lordships have the powers to grant that stay, so please grant me that stay. Commissioner would tell you that no, I can't grant you the stay. Be clear, we'll dispose of the appeal, and you would do nothing. So the next thing we do is, when I say we, I think of my team that time. The next thing you do is you keep a writ petition ready. The moment your bank account is attached, you also file a writ petition against the commissioner, asking him to exercise the powers. Mandamus, you're saying, look, you have the powers. You can't. Once you have the powers, you have the corresponding duty to use these powers when circumstances so warrant and justify. So sometimes, no matter how informal they are, informally they will tell you in private, no, I'll not deal with your stay, please forget. Or they'll tell you, 20% karo, aisa karo, and all that. They would try to be very dismissive of the legal framework. So you have to handle these things tactfully also, and remember that it's a part of the strategy also. I mean, whether you get legal relief or not. But then, as I said, I've been fortunate to see some very, very bright people, and I see many of them even today. I mean, I read some judgment, and these judgments from the commissioners are brilliant judgments. They are at par with the judgment you would read of a high court judge. So it's quite individual, quite personality centric, I would say. So you have to have the advantage, disadvantage of doing this informally. You can talk about it. They may be dismissive of the law, but keep, you have to be very firm on your arguments. I think most of the time you have to be, I do not know what are the trends now, but till 20 years ago, the trend used to be that written submission side was kept on the stronger side, because even if you don't listen to me, you will at least accept the paper, then do whatever you want to do. Then remember the importance of the grounds of appeal. How do you draft the grounds of appeal before them? And I said, which ground, how aggressively you pursue or you don't pursue. That's another important area. And then one of the areas which gets often ignored is the statement of facts. I don't know how many commissioner appeals really read the statement of facts which is written, which is filed along with Form 35. But when you are doing it, you have to be extremely, extremely careful. Because I know at the tribunal stage, many times this question comes up and they say, look, this is an issue, this is an uncontroverted fact. And you say, how is it uncontroverted fact? You say, look, I had said it in Form 35. In my statement of facts, I said it remains uncontroverted. This is going to the commissioner, this is going to the assessing officer. And I can tell you that if you are smart enough to draft your statement of facts properly, highlighting what needs to be highlighted, even if nobody reads it at one stage, please remember this remains on the paper. At some other stage, people give it the importance which is required to be given. And anything which remains uncontroverted and is stated in the statement of facts has huge, huge importance. Then evidences. Please also remember that additional evidences being accepted at a subsequent stage is quite a difficult task. So you have to be extremely careful about making sure that all the relevant evidences are given before the commissioner. Whether whatever he does to it, he accepts it, he doesn't accept it, but then don't ignore it. Then, of course, I was talking about written submissions. That written submission is very, very important. And written submission, usually the practice is that for several reasons. I can tell you that today, if I'm in the tribunal, it has something to do with one written statement which I had filed. Mr. Dongza Thong was on a bench, and incidentally, Mr. Dongza Thong was on the selection committee which selected me as a member of the tribunal also. And Mr. Dongza Thong, a very gracious and a very fine gentleman of an accountant member who rose to become president of this tribunal. He was on the bench and I was assisting a senior lawyer. And when he was looking at the paper book, he said, he told the DR, he said, look, who is giving this written submission? And my senior counsel immediately pointed out. He said, sir, he's the young boy. And he said, hey, this young man has written almost a thesis on this point, and you haven't dealt with a word about it. So he liked the written submission so much that he pointed it out in the court. And then if it's a coincidence, quite a coincidence it is, that a few years later I was selected as a member in his hands when he was on the committee. So your written submissions get read, they become part of the paper books, and you can write. Even if somebody is dismissive of what you say, he doesn't give you much time. Please don't mind that. You file your comprehensive written submission, dealing with all the arguments that will be, of course, subject to whatever strategy you may have in mind with regard to the legal issues. Because remember a fundamental thing: if there's a legal issue which you have not taken by chance, by design, or for whatever reason at the commissioner's level, you can always take it up at a higher level. That's what the law is. It is not necessary that each legal argument that must be adjudicated by the tribunal is something which has been decided by the commissioner. So many people, as a part of the strategy or for whatever reasons, they think it's proper not to impress upon certain arguments before the commissioner, and then they take it up at a later stage. But those are the things you have to bear in mind as to how, what your strategy is, what are the evidences which should be there, what are the grounds which should be there, how to draft the grounds of appeal, in what particular manner it should be done. You have to be careful with this. And when you look at the grounds of appeal, please learn from, you have to be brief, you have to be precise, and then you have to leave some portion which are what you call delightfully vague, so as to cover the points left out. This could be particularly with regard to the legal issues. So that probably we need another session for how to what are the precautions in drafting the grounds of appeal and the statement of facts. This can go on for days. Then going to the next slide, that is about the appeals before the tribunal. We are extremely short on time. As a matter of fact, okay, we still have time. Good. So, but still, can you go to the next slide, please? So that is appeals before the tribunal, and then remember that you have a time frame within which the appeal is to be filed, and once that you have to make sure that appeal is filed in time. But never mind, even if there's a delay, you have to seek a condonation. Then What are the grounds on which condonation is done? I mean, you have the case law. I will not go into the nitty-gritties of the case law. You have a whole lot of decisions on this. But broadly speaking, I can tell you that tribunal has been fairly reasonable on this, and sometimes a little lenient also, in the sense that wherever you have a just cause for the delay, uh, at least tribunal is found to be fairly cooperative in condoning the delay. And of course, it is illegal. It's not because the tribunal does it. It's because the lordships of the honorable courts above have laid down the guidelines where they have said what are the circumstances in which the these delays are to be condoned. You would do well to read those decisions. And in this modern world where Professor Google can help you out for anything, I'm sure he'll help you out for this also. And those within that framework, you have to move a condonation petition, attach an affidavit if you wish so, which is more appropriate. Make out a case on how to why the delay is bona fide, which is the true test. Then you have the grounds of appeal. And remember, when you are before the tribunal, you don't file any new statement of facts. Of course, in some cases, I see that on the file, but that's not what the law requires. All you need is the statement of facts as filed before the commissioner, because the same is to be attached here. And that's the reason I'm saying this is where it's very important. If the same statement of facts comes here, and if some portion of that doesn't get controverted by inadvertence or by looking at it casually or for whatever reasons, you have an edge at this stage of the tribunal from that point of view. Now, how do you draw the grounds of appeal? You have to be extremely concise in the tribunal. You have to write very briefly, succinctly, highlighting the exact controversy. Don't put arguments into this. Don't put case laws into this. Just keep the focus on. And as a matter of fact, there is a school of thought, whatever it's what, that even if the ground is slightly vague, which leaves the area of covering some, which leaves the scope of covering some areas which are not identified at this stage, that would also work. And also remember the difference between new grounds and additional grounds. As I said, you can take up any of the issues in the tribunal in the grounds of appeal. But if you take an additional ground, that is only when you don't set out those grounds in the Form 36, which is filed at the time of filing the appeal before the tribunal. If some ground is not taken there, then you take the additional grounds. It may be a new ground, doesn't matter. But additional ground would mean that this is something which is not given in the stage 1 of filing the appeal before the tribunal. So that distinction is to be borne in the mind, in the sense that an additional ground of appeal, tribunal is at liberty to accept or not to accept. But even if the ground of appeal is there, it could be dealing with a new issue, which issue was not there earlier. So tribunal has to deal with this, and of course, then in whatever way they decide, they might even say that it's wrongly taken or rightly taken. I'm not going into those legal discussions, but the broad question which remains is that an additional ground is a ground not taken in the original grounds taken before the ITAT, and that is as a part of Form 36. Normally, what really happens is, particularly I saw this in Ahmedabad more than anywhere else, that you file one additional ground, then you file another additional ground, then you file yet another additional ground, which makes things very difficult, not only for the tribunal adjudication, but also for the record keeping. So it could be worth a thought that when you file an additional ground, rather than filing an additional ground, you file a revised ground of appeal containing the original as well as additional, and then highlighting it perhaps. But those are the procedural aspects. This is not the day for the procedural aspects. I'm sure there'll be some other day when we'll discuss at length as to what really goes on, how do we improve it, and how you can have some takeaways on these points. Then there are early hearing requests. When you say, please take up my case out of turn hearing basis. Now, what are the trends about it? For example, if there's somebody in a case regarding 263, invariably early hearings are granted. There are cases of senior citizens, we always take them up. If there's a covered matter, you can always move an early hearing petition. Earlier, these petitions used to be only administrative petitions, but even these administrative petitions come up for a hearing, which is a very brief and short hearing. But then you have to really understand what are the usual trends and what are the categories covered. From my experience, I can you can make out a case of undue hardship to be assessing. Those are the cases for the early hearing where you can make a case that These are covered matters, these are the matters which are going to block proceedings. So all these are connected matters, and that's all of the matters there. So, but you again, you have to keep your eyes and ears open. You see the trends which are happening in the courtroom. Then I mentioned to you about stay applications very briefly about Mohammed Kuni's case. Of course, there today we are in a different situation. We have on the stay applications also. There's an amendment in law, and many people perceive this amendment to having to be something which is affecting the powers of the tribunal, and a minimum sort of pre-deposit has become essential. But then those things apart, briefly speaking, where you have a case made out for stay application, you can move a stay application, seek a stay on collection of demands, recovery of demands, subject to whatever is the legal framework and the modalities there to, subject to conditions they deem fit. And what are the related factors? Of course, first and most important related factor in everything is the prima facie case. If you don't have a prima facie arguable case, nobody looks at your stay petition. And you have to see whether this is a case which probably bench thinks is something of a strong case. Otherwise, stay applications will not be taken as a matter of course. And then you would also see, well, what is the balance of convenience? Is it genuinely required? Is it something which is the balance of convenience says that yes, stay can be granted? So, as I said once again, then there are different, these are different facets of what really goes on before the tribunal. And I'm sure you will have other occasions, other speakers talking about these things in great detail. But then tribunal has the powers of granting the stay, and this is something you might find very handy when it comes to protecting the interest of your SSE. Then adjournments, of course, I was mentioned about modification of ground, additional ground, and additional evidence. Remember, additional evidence is not something which tribunal is bound to accept. You have to make out a case. Look at the procedural requirements, and we have a very brief set of rules. If you look at the income tax rules that thick, there will be hardly 10 pages of the ITAT rules. If you read those ITAT rules, you will also find out the procedure. You will also find out the procedure as to what is the procedure involved. So keep these procedural things in mind when you are before the tribunal. Then expert witnesses, commissions, and remand reports. Expert witnesses is something which is quite futuristic. But yes, I think it is something which is going to happen in a very short period from now. Commission is when there could be two kind of things. One is the bench itself goes to that place and sees it on the spot, or bench sends somebody. From my experience in the income tax tribunal in the last 20 years, I have seen only two occasions. One was the occasion when, if I remember correctly, it was Nestle plant in Delhi benches, where we saw where the tribunal members went there and they wanted to see how the leakages part, because the claim for leakages was taken to be so exorbitant that not exorbitant, so high that it was not accepted by the income tax department. And Mr. Ajay Vora, if I remember correctly, Ajay's argument was that please come and see it for us, see it for yourself. This is how the system works. This is what our flow chart is, and that is how these kind of additional wastages take place. I mean, higher wastages take place. I was not on the bench, but I was a member at that time. I don't remember which was the bench, but a bench did go there. There was another occasion in my career when I was in Calcutta, and I was with Mr. Mahavir Singh Ji, who is now my colleague vice president in Mumbai, holding charge of Chennai branches. And both of us went to one port trust facility in Calcutta. And the issue before us was whether that particular equipment can be taken as an R&D equipment or not. And we had to actually go there, and we were honestly shocked and surprised to see what we saw, because what was being argued in the courtroom could not have given us an imagination or understanding about what was actually happening in the field. And I'm so glad that we did go there. And we had the benefit of guidance by a very eminent senior advocate who is no longer with us. He passed away last month, Mr. N.K. Poddar. He was a former council member also. He was a chartered accountant and lawyer, and then he became a senior advocate like Mr. Saparkar. And Mr. Poddar also went there. We had people from the income tax department, 2 commissioners were there. So those are these are the things which really happen. But I haven't seen many such requests coming these days. But you must understand that in a fit case, it could be quite possible for you to actually ask for a visit or a commission or an expert witness or at least a remand report. This can be asked for. But as I said, out of these three things, first is futuristic, that's expert witness. Second is something rarely used. Third is also not many times it's asked for also. But whenever it is asked for, it is done. So these are the peculiarities of the appeals before term. Now let me quickly go to, just before I wind up, to the next slide, which is appeals and writs before the honorable courts. Can you please move on to the next slide? Can someone move to the next slide, please?
Just a minute.
No. Before that. So yes, that's it. Now this is about the honorable courts. First, of course, the appeals against the orders passed by the tribunals go there. Now reopening and sometimes actions of the AOs are challenged in the writ petitions. That's also part of the litigation management. And as a chartered accountant, you can't be part of that process, but yes, you can be part of the decision-making process, what to challenge, whom to challenge on the technical side. And for example, in the reopening cases, many times you are advised to challenge the reopening at that stage itself. Administrative action authorities, there can be wide varieties of actions where you say, no, I don't want to wait for the appellate process. I must take it up right now and in this manner. Those are the areas which go to petition. Even when the matter is before CIT, I gave you the example of the stay petition. When, for example, you have moved a stay petition as a matter of strategy, and in the meantime, a coercive action takes place against you, and then you move to the High Court, asking High Court to direct the CIT appeal to dispose of the stay petition. In fact, you are just buying time for that. So these are the, this is the kind of strategy, and you have different kind of writs. Once again, this is a different topic altogether. What are the kind of writs? What are the kind of writs, and what are the stages at which it is done? I can tell you, and I mean, at the cost of modesty, I have to tell you this: that when I was in practice, and particularly in mid-90s, I had several occasions when I was not only quite a bit involved in the whole process of litigation, but I even drafted the petitions because we used to keep the draft ready. And my senior was Dr. Devi Prasad Paul, who was, of course, a senior advocate, a minister. He was Minister of State for Finance for some time, and a very eminent lawyer, parliamentarian, MP Lok Sabha. He was later part of the Narasimha Rao cabinet. And he was gracious and very kind, very generous man. He would encourage me to prepare the basic draft, and then it will come to him through some other lawyer, and they'll change it. So those were the initial years of computers. So keeping it handy on the computers used to help us. So it's like a format is ready. So I mean, one shouldn't think the chartered accountants have no role in this. Chartered accountants have a role in this, and that's an important role, because when you are the one who is taking a call on what litigation is to be followed, how litigation is to be followed, whatever, what is that you are, how do you want to explore the legal options, then it becomes very, very important. Then before I go to next slide, there's just one point I must make, and that is a point with regard to your becoming, possibilities of becoming a tribunal member or conciliation boards or expert witnesses. As of now, there's one part, which is real part, that is the ITAT, on how can you go to the ITAT as a member. And then that is, as I said, this is a process, the selection process takes place 2-3 years, after every 2-3 years. When you're in touch with any tribunal member or anyone who regularly practices before the tribunal, you would know when it takes place. And then you have to, decide at, how do you present yourself and what call is to be taken. And I think this is a very interesting career option. I'm myself a beneficiary of this. I would encourage you to keep this in your mind while planning your future moves. And also prepare yourself. We can have some other time if we discuss what are the kind of things we get discussed, what are the considerations, and what are the broad things. And I can tell you, if you have a good knowledge of law, of the procedure, of what is hot in the ITAT, there are reasonably good chances that you will have a fairly good chance of being seriously considered for the post of the member. What you need to do is, number one, be good on the legal side, on the income tax law. Keep track of what's hot and what's relevant, what's present, And you can always do that, by interacting with those who are in tax practice. And now you have this itatonline.org, which is a website of our ITAT Bar Association Mumbai. It keeps you quite updated about the tribunal. So I think that's one of, as a matter of fact, when the jobs come, when the member vacancies advertised, these are also always posted there. So, and this also tells you about what are the recent orders, about the discussions, about certain blogs. So you can keep yourself in tune with what's hot there, and you read the tribunal judgments, because, and what are the issues in the tribunal mainly coming. Now, fortunately, we live in a world where it's very easy to get all this information. So I would urge you, if you're thinking of ITAT as a career, to be an accountant member. And incidentally, it's only country perhaps which allows ITAT an accountant member in the tribunal. I think that's something we are so fortunate to have this in India. And I would think that you should always give it a chance. I mean, there's no harm in it. What probably they look for is, A, you have a reasonable income, which is not too high and not too low. So if your return income is fine. B, you have a good understanding of the legal framework about the income tax, which is, I can assure you that if anyone takes it seriously for 6 months to 1 year, you can always do that. C, whether you are conversant with what is hot in the tribunal, what are the issues with regard to the taxation. D, with regard to the general world of taxation and law. So, those are the things. Now, can we come to the next slide? So, yeah. Now I'll quickly wind up, just 5-10 minutes more. The initial exposure. All right, all this theory is ready. Now you have already been taught how to make what they call butter chicken, but how to get a chicken. बटर चिकन तो तभी बनेगा ना जब चिकन हाथ आएगा. तो वो शुरुआत कहाँ से होगी? तो शुरुआत तो एक तो सबसे इम्पोर्टेंट शुरुआत है कि एकेडमिक फोरम्स, जितने एकेडमिक फोरम्स मिले, जितने ऐसे मौके मिले इंटरेक्शन के. और मैं बार बार आपसे कहता हूँ क्योंकि मुझे बहुत जलन होती है. मेरे टाइम में तो ऐसा कुछ भी नहीं था. अगर हमको तो कोई साहब सेमिनार अटेंड करना होता था तो पहले पेट्रोल पड़वाना पड़ता था, फिर जाना पड़ता था, दूर दूर जाना होता था, वहां बैठना पड़ता था, 2-2 घंटे वेट करना पड़ता था. You people are so fortunate that you live in the world where you go to YouTube and you see 10 seminars. Attend these events, see what's happening, but when you do that, please have a very narrow focus. Please keep your focus to, जैसे अर्जुन की को निगाह आंख पे थी, उससे उसको दाएं बाएं मत जाने दीजिए. अगर आपने टैक्स पे दिल लगाया हुआ है तो बाकी चीजों को छोड़ दीजिए. जो भी कुछ कर रहा है उसको इनिशियल फोकस करिए, उस पर लगे रहिए, एकेडमिक फोरम्स करिए, जजमेंट्स पढ़िए, और ये जरूर तय करिए किसके जजमेंट पढ़ने हैं. क्योंकि लेकिन एक बात ध्यान रखिए, जजमेंट एक इनपुट है, इसलिए नहीं कि वो लॉ आपको, बहुत सारे जजमेंट्स हैं जिनमें कुछ नहीं मिलेगा आपको, पर आपने तय करिए. जैसे मैंने आपको कुछ नाम लिए, पुराने जजमेंट्स हैं जो 100 ITR से पहले के हैं. आप किसी भी अपने सीनियर से बात करेंगे वो आपको बताएंगे. और हमारे ट्रिब्यूनल में बहुत सारे डिस्टिंग्विश्ड लोग हैं, मैंने बताया, जो मेरे अपने रोल मॉडल्स हैं, जिनका मैं फैन हूँ. आरवी ईश्वर साहब उनमें से एक हैं, और एक हमारे अहमदाबाद से ही हैं प्रदीप पारिक साहब. उनका भी मुझे बहुत जजमेंट मैं बहुत पसंद करता था, बहुत अच्छे जजमेंट्स लिखते थे. उनको आप देखिए, आप गूगल में जाइए या आप जो सॉफ्टवेयर यूज करते हैं सॉफ्टवेयर एआई के लिए, प्रदीप पारिक, आरवी ईश्वर, उनके जजमेंट देखिए. उनके फिर आप देखिए आजकल के जजमेंट्स, आजकल के कौन से जजेस हैं या कौन से मेंबर्स हैं जो काम का जजमेंट लिखते हैं. मान लीजिए मेरे कुलीग ब्रदर शुक्ला दिल्ली से लिखते हैं, अच्छा लिखते हैं, आप उनको देख सकते हैं अगर आपको लगता है तो. कुछ लोग हमारे आप ही के गुजरात के गेस्ट हैं ट्रिब्यूनल को, हमारे महर्षि साहब हैं, उनके जजमेंट लोगों को पसंद आते हैं, उनके आप देख सकते हैं. आइडेंटिफाई करिए और आप देखिए कि आपने क्या करना है. और एक थर्ड पॉइंट बड़ा इंपॉर्टेंट है कि जो कोर्ट एंड ट्रिब्यूनल्स हैं, जो वर्चुअल कोर्ट्स एंड ट्रिब्यूनल्स हो रहे हैं, प्लीज उनको देखिए. मैं आपको बोलता हूँ, हमारा बॉम्बे ट्रिब्यूनल है, हमारे बॉम्बे ट्रिब्यूनल में हम लोग वर्चुअल कोर्ट्स कर रहे हैं आजकल. अभी मैं ऑफिस बैठा हूँ, वहाँ जरूर आया हूँ दोपहर बाद, मैं घर से कोर्ट करता हूँ कई बार सुबह को. और हम लोग कोशिश करते हैं कि जब आप कोविड में हैं और कीपिंग योर सेफ्टी कंसर्न्स इन माइंड, यू डोंट वांट टू कम हियर, so I mean the litigants argue from their home, DR argues from his office, and our members sit in their home office or the office and hear the cases. But the best part is these proceedings are open proceedings. As a matter of fact, you can go to our website and see what are the meeting IDs for which courtroom and what are the passwords for those courtrooms. At least I have seen to it that they work in an absolutely transparent manner. Sometime meeting the passwords do not come by Friday. For example, next week passwords are still not in public domain. As I was talking to you, I've got a paper on my table which reminds me that I have not given my password. So we have to set the meeting rooms, put the passwords. But once these meeting rooms are set, the passwords are set, any one of you can go to the internet, go to WebEx or whichever forum, whichever platform, whichever forum is using, key in that meeting ID, key in the password, and see what's happening. And sitting in your home, maybe having your coffee, or maybe doing some other work, or playing with your dog, or playing with whoever else, you can also watch what's happening in the courtroom. I'm told that this is also available for Honorable High Court Sabha. So I do not know to what extent these things will be useful for the for the High Court, but tribunal certainly yes. And then identify which courts you want to attend. Which is what you want to see. And when you see the courtroom, you know the ITA numbers, you know which cases they are hearing. And when you attend the virtual court and say this is the case he heard, then take a note of that ITA number somewhere. After 5 days, 10 days, 15 days, go to our website again, read the judgment as to what is written. Then you will know the trend, because all our judgments are online. Any judgment which you want to read of any of one of us past, you just need to know the ITA number in here. If it's 1728 by Mumbai by 2018, you have to go to our website. It will take you to a menu where you have to give the ITA number, location, and the year, and it will tell you the status of the case, which includes the judgment. So then once you see this, then you will see what is being argued, what was being argued in the courtroom, how it was being argued, and what ultimately happened. I mean, this is one of the collateral advantages of the COVID days. I'm sure many of our benches do it. I know for Mumbai benches, because that's where I'm posted and that's the zone I'm handling. I'm sure many of my colleagues must be doing it. You should, if you could talk to your own, if you talk to the people who are practicing in your own city, then they'll also tell you which are the virtual courts which are going on here. Initially, some places the number of cases will be less. The cases will not be as complex, but it will give you a beginning. Then, when the COVID era is over, I wouldn't say COVID era. This great huge problem part is over. Then you can actually go to the courtrooms and watch the proceedings. Particularly, watch the lawyers you admire. And once you start going there, of course, there are some internship programs also. We were also thinking of the. We're also thinking of having an internship program, but somehow things haven't fructified. They are still in process, so we can work out those things. And then read the things which are of the applied use. The word use is missing, because this is a PowerPoint I prepared when I was sitting in the office just now. So some things are missing. Whatever is hot, whatever are the relevant things, identify them. Use Google Leads, use the ITAT online leads, follow them, and then please read it. If you can write articles, nothing like it. This is one of the best things. I can tell you, I started writing articles for Business Line. That was the time it was a new newspaper launched from Delhi, from the Hindu family, and that's what made me start doing my initial research work. You can find art. You can think of writing articles maybe for the vernacular press, for the mainstream press, for the smaller magazines, for something or the other. You will find some forum. Any academic pursuits, any training programs, you should always look forward to in your focused area. Don't go beyond that. And done internship and attachment in the large company. But remember one thing. Last time I had a seminar in the ICAI, I got some messages regarding desire of some people to learn international tax and be attached. But I tell you, from a practical angle, when I talked to the prospective people who could engage them, the practical difficulty was that everyone said that what is he bringing to the table? What can he do for me? So remember, you have to take something on the table. Now, what will you take to the table? Your awareness about the current case laws, your domain expertise in a specific area, your ability to draft things, to draft papers well, or whatever else you can bring to the table. But nobody does anything out of charity. People do it because they have their vested interest. Because they have their interest. So when you think of joining in a large company, probably, or a group, I think this is what it becomes most important. There are things. Okay, we are running out of time. So you had given me 2 hours, and my watch tells me that 1 hour 43 minutes are already over. Even if you go to the next slide, there isn't much, something very general. Can you go to the next slide? It's about handling people. Be polite, but please be firm. Politeness should not be taken as a weakness. And I can tell you that if you don't remain firm, this is not, litigation is not the word for you. You have to be very firm. You should be polite. Your integrity should be absolute professional integrity, no question about it. Intellectual integrity, highest order. As a courtroom warrior, you do whatever you want. But once you are, outside the courtroom, and in the courtroom also, if you, it's not that you do tell them what works against my client, but please don't mislead on factual aspects. Identify a proposition. Say this is what I have in support of this proposition. Say this is a proposition. But your integrity, professional integrity, intellectual integrity is absolutely important. Remember, at the end of the day, in litigation practice, your fate is in the hands of some people. And the only way you can be successful is that when these people are with you. I don't want them to be with you for personal reasons. They want to be with you institutionally. And they'll be with you institutionally when you become so tall. वो कहते हैं ना, खुद ही को कर बुलंद इतना कि खुदा खुद बंदे से पूछे कि तेरी रजा क्या है. ये कोई बात कहानियों की नहीं है, सच्ची बात कहानी है. जब आप सही होते हैं, अपनी बात सही से करते हैं, आप ठीक ठाक होते हैं, तो कोई आपको हैंडल नहीं करता. आपकी पब्लिक इमेज, उसकी बहुत इंपॉर्टेंस है. समय के लिए छोड़ते हैं. Follow the norms. Please, you have to follow the norms. Don't deviate. Don't look for the shortcut. With clients also, speak absolute truth. As I gave you the example, next slide, please. As I gave you the example, tell the client that what the correct position is, and also tell the client that what your strategy is. Don't mislead anybody. In a public conduct, as I said, you should mean business. No, I wouldn't encourage anyone to be over soft or to be to be somebody who would listen to take every nonsense. Please don't do that. You are doing yourself a great disservice. Your reliability, your fairness, your modesty, that's something very important for public, for your conduct as a public figure, because career litigation is something of a public figure. And remember, your clients are who? Your clients are your own colleagues. Your clients are your own classmates. Because you have a large, everything which comes to a litigation lawyer comes from chartered accountants. So unless your image is good, you are absolutely done for. Public trust is something of the biggest asset. Never ever play with this. If you want to get involved into teaching, writing, speaking in public, please do that. No shortcuts. And the final slide now, on the last page. Can you move the last page, please? Next slide. Yes, that's it. But as I said, the answer is how to get things moving. For 2 years, I would suggest, if you are not in litigation career now and you want to be in litigation career, 2 years, please do the groundwork. And the groundwork means being up to date on what's in the part of the current judicial process, being up to date about the current judicial thinking. It doesn't mean that you have to look at every judgment, but it does mean that you know about what are the topics being discussed. Then, when your initial clients, my experience is that public sectors, public bodies are the best clients to begin with. They are the ones who can probably, who are likely to give you the work initially. Large litigation centers, lawyers and clients, large litigation centers are probably the places where you can get something. And then you upgrade your roles from time to time. You have to upgrade your roles from stage 1 to stage 2, from a researcher to a documentation, to the briefing counsel, to the arguing counsel, to the tribunals. Decide, take one step at a time. Then decide your prospective clients, targets. You decide, as I mentioned about public bodies. You think public bodies, it doesn't work, then look for the next thing. And then from time to time, review and improvise the needs. Thank you so much for being such a patient listener. I haven't got many messages on my WhatsApp. There's only just one message. And this message says, sir, being a first generation CA in family, even though interested in litigation, in the initial years, we have to involve in general practice and so find difficulty in building career in this field. Yes, I'm like one of you. Young man, I can tell you that my father, I have great pride in saying this, that my father is no more now. He was a soldier, and I spent my childhood and youth in the army cantonments. I had absolutely no idea about what goes on in the world outside, and it was quite a challenge for me. But as I could see, that once you start doing some work, some initial, you give opportunity for people to take notice of you, and then these things work. And I gave you some of the leads. You can work on that, and please don't wait for the first client to start taking tax seriously. If nothing else, today we have a very active institute which gives huge platform to youngsters. If nothing else, be a resource person for the institute and identify the area in which you want to be. Don't look at the entire income tax. Identify a niche area, identify a small area, and start your visibility. Teaching could be another idea. Writing articles, as I said, could be another idea. So I'm sure you will find enough books in the self-improvement sections of any good shop or on the net where you will find how to market yourself. But the first thing is commitment and curiosity and domain, curiosity about the process and domain expertise. Thank you so much. Thank you so much, everyone. Thanks for patience. I've overrun the time. And thanks a lot.
Thank you, sir.
Sir, the question is, there is one question which is on the screen, that the companies do not trust the new generation chartered accountant.
I'll read it. The question: the companies don't trust the new generation chartered accountant that they would be able to argue for them and that they hire an old IT practitioners, whether they are CA advocates. How can we get the work? Yes, I agree with you. First of all, I said the whole business is building trust. This is the challenge. And I give you the example that there will be holes and how to fill the bucket. These problems will always be there. I can tell you on my own case. In my own case, the first client I got was probably a small public sector. But then once you start developing your work, see, one good thing in the world is that whether you are good or bad, whatever you do actually is generally gets known. And that's the reason I said give yourself 2 years. 2 years in round one. And in the round one, be very good in one particular area. Pick up a niche area. If you want to pick up transfer pricing, pick up transfer pricing. And you are very fortunate to be in the times when ICAI gives you such a huge platform. Try to be a resource person for writing their material. Try to teach the students. I can tell you there are many people like DB Desai is one of them. Now Dilip Bhai is he's a rich man. He had taken over one of the biggest companies. He bought the practice for untold some 50 crores. He's one of the richest persons. But you know what? His father was a school teacher, and the way he saw to it that he gets recognized was by teaching the CA students. So first job is how to catch the limelight, how to be known to the public. So you have to find the ways of doing it. Get into teaching, and you have to develop an image of being someone who is good in this area. And I gave you one of the tips that initial areas, when you look at the first clients, probably businessmen would not take those kind of chances. Try with public bodies, try with the public sector, try with the other institutions where they would be less obsessed with the results. But I can tell you one thing: once you start doing it, trust me, you will find that it was so easy. I mean, why didn't I can give you n number of examples. Today there are 3 names which come to my mind from Delhi bar, who had no work. There was one particular person, I don't want to take his name, but today he's one of the star speakers, and the entire work is generated by his becoming a star speaker. And when I was in practice, he was absolutely briefless. So you have to create that.
Very true, sir. And no, there is no other question, sir.
Thank you so much.
We are with the question, but I can definitely say that whatever you have said, sir, it is very much correct that in initial year you don't get any work, and young generation chartered accountant should wait something, and they have to explore, have to come or enhance their experience, and they have to evolve, and then after definitely work will flow like
absolutely anything. And the work will flow from your own colleagues. Because if there are 200 persons attending this webinar, not all of them will work in this direction. If I have 2 persons in this webinar who think of this tax career seriously, I'll be fortunate. So think of remaining 198 as your clients. And litigation practice is one area where you don't get clients. No direct client walks into you. Your own colleagues are your clients.
Perfect. Sir, thank you very much for your presence, guiding us, and your words of wisdom. Sir, when you are there, it really improves our confidence and definitely motivates us to do things in a right way, in a right perspective, and with such a integrity. Sir, we at Ahmedabad branch are very much thankful to you for sparing your time. Thank you very much. Thank you very much, all the participants, for your.
Thank you very much, everyone. Thank you very much.
Thank you.
Bye-bye.
We are now ending this webinar.